you so much for explaining to us what the heck is going on with the Equal Rights Amendment. First of all, can you tell me who you are and what your job is?
Hi, Kamala. Thanks for speaking with me today. I'm Nicole Vorrasi Bates, and I'm the founder and executive director of Shattering Glass. It's a nonprofit dedicated to gender equity and gender equality, and I have been actively involved in the fight for the Equal Rights Amendment, and most specifically, since November, trying to get the Biden administration to publish the Equal Rights Amendment as our 28th Amendment to the Constitution as required by law.
Thank you for your hard work. Can you tell me why that's not happening, though? I'm unclear. The ERA was ratified by the 38 states. Shouldn't it automatically be published?
It should. Pursuant to federal statute, it's a ministerial act. And what that means is that there's no discretion. Under the statute, the U.S. archivist, who is a librarian, a member of the executive branch, is tasked with record keeping. They count ratifications as they come in. And in this case, the Equal Rights Amendment was required to be ratified by 38 states. And once the 38th state ratification comes in, the archivist is required to publish. They count, they make sure they approve the exact same language on its face. It's not a substantive determination. And then they publish the revised Constitution. At that point in time, if someone has a challenge to the Constitution, they can bring it. But the archivist is required to publish the Constitution.
So in this case, however, he did not do that. In this case, what happened?
So in this case, the Trump administration, its Department of Justice, infused politics into the constitutional amendment process. A few weeks before Virginia became the 38th state to ratify, the Trump administration issued a memorandum that stated the deadline had expired. The archivist could not publish the Equal Rights Amendment, and that any efforts for an Equal Rights Amendment were dead and people could try to start again.
So then 46 million women put Biden-Harris in office, in great part because they believed that they supported women's rights, women's equality, reproductive rights, equal pay, a stop to the gendered violence that we experience, et cetera, et cetera. But what has actually transpired since this administration has taken over vis-a-vis the ERA?
Yeah, that's a great point. Yes, women put the Biden administration in office. There's no doubt about that. And since that time, there have been efforts by countless women's organizations to get the Biden administration to publish the Equal Rights Amendment. 3 senators and 2 congresswomen reached out and wrote to the Biden administration explaining why the Trump memorandum was inappropriate and should be rescinded, and the Equal Rights Amendment should be approved immediately and published. I shouldn't say approved because the executive branch has no role in this entire process other than counting and publishing a new constitution. That's the sole role of the executive branch here. Since that time, the only other thing that's happened is that the Biden administration continues to fight against the Equal Rights Amendment in court. Most recently, this past week, arguing that the states who are trying to get the Biden administration to publish, these are the last 3 states that ratified after the alleged deadline that is in controversy, initiated a lawsuit, and the Biden administration is saying that they were not injured. So the lawsuit can't go forward. And this is the same position the Trump administration had. And to make matters worse, they went so far in their brief as to argue that the deadline has expired. which
So
is
tell
contrary.
me, yeah, tell me, Nicole, everybody that that is against or even suspect of whether ERA is in fact the 28th Amendment brings up this deadline. Tell me about the deadline and tell me why you believe that it's invalid and unconstitutional.
So the deadline, first and foremost, the Article 5 of the Constitution talks about how you amend the Constitution. And it says nothing about deadlines. There have been instances where deadlines have been used. But the interesting thing here is, even assuming deadlines are permissible under the Constitution, which I believe remains somewhat of an open question, it wasn't in the Equal Rights Amendment. It was actually in the preamble to the Equal Rights Amendment. It was not sent to the states to be voted on. So
wait a minute, let's work through that. So in other words, what you're saying, if I understand this correctly, is that what was voted on by the states was simply the language of the ERA. They had no input or choice on whether they believed 7 years was an appropriate amount of time to give ERA, certainly in context of the 27th Amendment receiving over 200 years to be ratified. Is that essentially?
That's exactly right. And under Article 5, the states and Congress are co-equals. One is not superior to the other. So there is a constitutional challenge to this deadline. There's a question of whether or not the deadline is even valid, and hundreds of constitutional scholars say it's not. But because Biden interfered, Trump interfered, and now Biden, the burden to prove injury is on the states, when it should have been published, and the burden would in fact have been on the opponents of equality.
So let me get this straight. Women have worked on this for 100 years. We have put in millions of hours of work, billions of dollars of efforts, and we have achieved what Article 5 demands, which is 3/4 of the state's ratifications. And now that justice is being foreclosed because Trump sent a memo and Barr, sent it to the Department of Justice. And now President Biden is continuing to support the idea that women are not equal. Is that correct?
That is correct. And one of the reasons why is that the Equal Rights Amendment bolsters our reproductive rights. And that has made clear by the people who oppose the Equal Rights Amendment, as well as even recent case law in Ohio, Utah, and most recently Michigan. Equal rights amendments and equal protection provisions in state constitutions have been used to defeat abortion restrictions since Dobbs, and before as well, but those are the most recent since Dobbs. So that was the driving force behind the Trump interference. And I can't say why the Biden administration is continuing this, as they profess to support the Equal Rights Amendment and profess to support reproductive rights.
That is so shocking. So you really believe that this block of ERA really had to do with trying to get rid of women's reproductive rights, almost sort of in advance?
Yes, for sure. I do believe that because of statements made, like, for example, when President Biden came in April of 2021, a few Republican senators wrote about how ridiculous the efforts were of the publication of the ERA. Now that Trump was out of office, they were actually concerned that Biden was in fact going to publish the ERA. And they said the sole reason is to save abortion rights. And they said why that was inappropriate. And some of those senators are the same people who wrote to the archivist in 2022 when he was leaving, before the Biden administration filed a brief in court opposing the ERA, demanding that the archivist not publish the ERA. So there were 10 senators opposing. So there's paper all over the place of motivation.
So, you know, I was talking to one of my friends that's a director of organizing in the labor movement, and he recognizes these tactics because these are the same tactics that corporations employ when they attempt to stop workers from achieving equality and justice in the workplace.
Sure.
It's really a matter of us getting the word out on this. And
Yes.
What do you think the reason is for Biden not to want to do this?
I really wish I knew. I have asked the White House. I have asked senators, governors. No one seems to be able to put their finger on it. And ironically, the statement, the closest we can get to a statement, is that same statement the president put out on January 27th, 2022, when the ERA was literally in effect. It was the text of the ERA itself says that the amendment shall take effect 2 years after the final ratification, to give the states time to repair their laws.
Equal means equal sent letters to all the attorneys general in all the states upon that date, letting them know that they needed to look at their labor laws and see whether they were discriminating on the basis of sex. And we told them they would help, we would help them. We heard nothing back from any of them. And from what we can tell, none of them are acting like ERA is law. None of them are fixing their laws. So when that lawyer this week said publication has no impact, that's so patently false, because wouldn't publication compel the states to look at their laws and start fixing them?
100%. The other thing it does practically is and this was brought up in court by one of the judges, by publishing, it then becomes included in the laws, and there's a presumption of validity. So then it would have to be challenged. So the burden shifts again, this key burden shifting. This gets back to the unions. It's like the tactic. Yes. So that's exactly what happened here. They preempted it and shifted the burden on the proponents of equality, more than half of the country.
Thank you, Nicole.